The most common estate planning mistakes and how to avoid them. My name is Michael Pevney. I am an estate planning lawyer in California. I serve the entire state. I set up estate plans for California families, and you can follow me for more estate planning information. I have hundreds and hundreds of videos out there, and if you live in California, haven't set up that estate plan yet, you can set up a time to meet with me for free by following the link in the description or my profile. So let's talk about the biggest estate planning mistakes that I, as an estate planning lawyer, often see. Well, first, number one, the simplest one is not having a plan at all. There are different statistics out there. Somewhere between 60 and 80% of adults have no sort of estate plan set up at all. No will, no trust, no power of attorney, no advance healthcare directive. And here's the biggest problem with that. Without an estate plan, the state that you live in decides where your property goes, how it's distributed, who it's distributed to. If you are, let's say, not married but in a committed relationship, that significant other will get nothing. If you want to leave things unequally to different children, if you want to leave things to charity, the state is going to step in and say where all of that money, property, all of that stuff goes. So we want to avoid that. So how do we avoid that? We set up an estate plan, whether typically the central estate planning document is either a will or a trust. Where I live in California, I think if you own real estate or have younger children, the trust is going to be that more central estate planning document, but a will in many, many places, depending on your situation, is great. And even if you don't have what you would consider substantial assets, it's a lot better to have something in place than nothing at all. Mistake number two, failing to update your estate plan when it comes time and improperly using beneficiaries. Now, beneficiaries avoid probate. Probate is the court-supervised, government-controlled, judge-approved asset distribution program that I described in the earlier first mistake that your property has to go through. It can take a very long time. It can cost a lot of money. In California, average homeowner, we're looking at about $45,000 to $50,000 in costs, a lack of privacy, and oftentimes a year and a half to 2 years in the amount of time it actually takes to get this stuff done. So let's make sure our estate plan is updated and any accounts that have beneficiaries are updated. And I'm going to give you a not so uncommon horror story. Not so uncommon is a little bit of a double negative. So a relatively common horror story. One great way to avoid probate is to use beneficiary designations. We can name beneficiaries on pretty much any financial account that we have: checking, savings, non-retirement accounts, retirement accounts, life insurance, and in some states, we can actually leave a beneficiary on our home so that it doesn't have to pass through probate. But it's going to completely avoid probate, avoid the trust system, and it's going to the person that you named, whether you still want them there or not. So here's one of those horror stories. Somebody starts a job, that job has a 401k, they're married. When they start up this retirement account, 10 years, 15 years, 20 years down the road, they're no longer married. They are divorced. And since that now ex-spouse is still noted as the beneficiary designee on those retirement accounts or that retirement account, and that person passes away, maybe they're even remarried, guess who's going to get that account? Guess who's going to get that money? The ex. This happens all too often. So when there are major life changes in your life, marriage, divorce, birth, death, we want to make sure that these beneficiaries are named and updated, especially in a divorce type situation. So that is certainly an important part to do. We want to review these beneficiaries regularly and sometimes updating them when there's a need for that. Mistake number three, focusing only on financial assets where you want them to go and overlooking healthcare decisions. So an estate plan, proper estate plan, a complete estate plan is not just about distributing assets, telling people where you want your money and your property. to go, it's also about planning for healthcare decisions if you're not able to make those decisions on your own. So where I live in California, and most states have equivalent documents, we have what's called an advance healthcare directive. That combines two things. First, it tells us what our end of life decisions are. Kind of like, do you want the plug pulled or not? Some places call it a living will. Some people refer to it as a DNR. It's kind of like that big decision. And we want that decision to be made by you before somebody else necessarily has to make that decision. So there's no conflict over that. It's signed, it's notarized, and the hospital has access to it. So nobody's stuck in a situation where they have to make a very difficult decision. Maybe there's even disagreement in that hospital room about what this person wanted. They told me this, no, they told me that. Well, guess what? They wrote it down right here. They signed it in front of a notary, or it's been witnessed by two separate people, and there's no question as to what that is, and the medical professionals are going to follow that. Second, for other healthcare decisions, we are going to nominate or name the people that are going to be making that decision on your behalf. So we want a primary person. Oftentimes we want an alternate person to be making those decisions for us again. So there is no difficulty or question about who that is. Similarly, for financial decisions while we are alive, but maybe incapacitated, we want a document, a power of attorney document, who we want the person while we are alive, but unable to make financial decisions, who that person's going to be, and make it clear. And we want it written down, and we want it signed, and we want it notarized. All part of an important part of a complete estate plan. Mistake number 4, choosing the wrong executor or trustee. So in California, sometimes it's called an executor or a personal representative for a will. The person that comes next is the trustee when we are using a trust and we want to decide on who that person is. We want to make that decision carefully. The biggest, they don't have to be a financial genius, but they need to be trustworthy, right? And they need to be willing and able to carry out those wishes, whatever your decisions are after you pass away. So sometimes people want to, if they have 4 kids, they want all 4 kids to be co-executors or co-trustees. I oftentimes advise against that because it becomes very difficult if there's disagreement there. Does it need to be a majority rule? Does it have to be unanimous? Oftentimes we want one person in charge and then always naming alternates if that person is, passes before you or doesn't want the responsibility or is unable to do it for whatever reason that is. So we want to make sure that that executor or that trustee, obviously we want to trust them, we want them to be honest, and we want to avoid any sort of conflict. So it isn't necessarily all kids at once. It isn't necessarily going to be the oldest first and sort of down the line. Sometimes we want a complete third party, like maybe a related person, like a sibling, or maybe a very close friend. So we want to pick the right executor, personal representative, or trustee. Mistake number 5, not properly considering the tax implications of your estate plan. Here's something that happens pretty often. People do know about probate, and in California, what a huge mess it is. So what they do is they add their own child to the deed to the house, and it is held now, as we say, as a joint tenancy. That means that the last person to be alive, so if the parents pass away and the child's still on the deed, the home just now belongs to them. This doesn't take into account taxes, specifically capital gains taxes. Property taxes is a state-by-state thing, so I'm not necessarily going to go into that, but capital gains taxes is a federal thing. So it would be as if the child purchased the home for what the parents purchased the home for. Oftentimes where I live, maybe that's $100,000 or $200,000 if that was 30, 40, 50 years ago. Now the home's worth $1 million. And if the child goes on to sell that home, they're going to owe whatever capital gains tax that is on $800,000 or $900,000 in capital gains tax. We're definitely looking into the 6 figures of just the amount of tax owed. We really want to avoid this. So we think it's a good solution for avoiding probate. Yes, it does avoid probate, but the much better solution is oftentimes to place that home inside of a trust, not conveying or giving any control of the child to that home until you pass away, making the child the beneficiary. And then we have what's known as a step up in basis. When the child inherits that home, they are now going to inherit it with a tax basis of what it's worth when the parents passed away. So if they sell the home relatively soon after the parents pass away, they're going to pay little to no capital gains tax at all. So that's not considering those tax implications. Pretty important. Mistake number 6, not properly funding your trust. So where I practice in California, I believe that most people that either own real estate or have kids under the age of, 25 or 30, if there are special needs issues going on or something like that, the trust, a revocable living trust, is going to be the main central estate planning document. But a trust only has power over property that is inside of the trust. So a trust has to be properly funded. When it comes to real estate, that means placing the real estate inside the trust. That means drafting up a new deed, hopefully with the help or assistance of a qualified estate planning lawyer, placing the home in the trust if it is a revocable trust with the people that set up the trust in complete control of everything. It also means maybe retitling certain assets like a bank account, potentially an investment account, into the name of the trust, or making the beneficiary, just like you can make an individual a beneficiary, you can often make a trust itself the beneficiary of an account, because a trust that has no assets inside of it is completely powerless. So we need to fund the trust. So those were the 6 biggest mistakes that I often see as an estate planning lawyer. I'll go through them again once real quickly. First, of course, having nothing in place, no estate plan. Second, not updating that plan every so often in beneficiaries when big life events happen. Number 3, only thinking about our finances and overlooking healthcare decisions. Number 4, choosing the wrong person to follow us, the wrong executor or trustee. 5, not considering the tax implications, especially when it comes to capital gains on real estate. And then, of course, number 6, not properly funding your trust. Once again, my name is Michael Pevney. I create estate plans for families in California. Please follow or subscribe to this page for more estate planning information. I got a lot of videos out there. If you live in California and it's time to set up that estate plan, in the description, you are going to find a link to set up a time that works for both of our schedules. If it's just a question that you have, it's very likely either been answered in one of the many hundreds of videos that I've created, or just ask it in the comments and I will reply as best I can. But if it comes to actually setting up that estate plan and it's time to do that, my time's valuable, your time's valuable, and we can, of course, do that together. Please subscribe to this page for more estate planning information. And thank you for your time and thank you for your attention.